The Department of Justice, and especially the Attorney General of the United States, has traditionally been understood to operate independently of the president whom appointed him. The Attorney General is supposed to be the nation's chief law enforcement officer, not the president's lawyer. Let's take Watergate, for example. Richard Nixon appointed Elliot Richardson as Attorney General in 1973. And when the Watergate investigation began to actually investigate the president himself, Richardson did not shut it down. He actually appointed a special prosecutor, Archibald Cox. And when Nixon ordered Richardson to fire Archibald Cox, Richardson refused. Former Attorney General Elliot Richardson resigned rather than carry out Nixon's orders. That is what Department of Justice independence is supposed to look like, folks. The president picks you, but the president doesn't own you. Because the president and the attorney general are both supposed to be serving the same entity, the American people, not themselves, okay? So what happens when a president appoints his own personal criminal defense lawyer to run the Justice Department? Well, we are finding out as Todd Blanche is making his answer to that question pretty clear. Here's what he told Kristen Welker on Meet the Press just yesterday.
Can you pledge that the Justice Department will always act independently of the White House?
Well, there's a big difference between saying we will always do our job and investigate any case and act independently of the White House. No, I'm not going to pledge that. And no attorney general should ever pledge that. The president, if I were to pledge I will be independent of the White House, what that means is that if President Trump says, I want the Department of Justice to go after every violent criminal in this country, which is what he has said, what you're saying to me is I should say, no, sir, I'm not going to do it. So I will act with integrity. Our prosecutors will act with integrity. We will prosecute without fear or any sort of favor. And that's exactly what we've been doing. And that's what every Department of Justice should do.
Well, I guess big picture, if the president asks you to do something that you feel crosses an ethical or legal line, would you do it?
The president will never ask me to do something unethical or legal or illegal. He never has. He never will.
So you got to listen, folks. The question is not whether Todd Blanche believes Donald Trump will ask him to do something illegal. The question is whether Todd Blanche is prepared to say no if, and possibly when, he does. And when Todd Blanche was asked whether he would take Donald Trump's opinion into consideration in an individual prosecution, well, his answer probably won't surprise you.
Should the president have a voice in individual prosecution decisions at all?
Every American has a voice in prosecutions. We hear from Americans all the time. As a matter of fact, many of our investigations start with an American citizen coming forward and saying they saw something. And so whether President Trump should have a, quote, voice, it depends.
Would you take his opinions into consideration when he says, I think this case should be revived? Will you take that into consideration?
So hold on. Will I take the President of the United States' view on something into consideration? Yes, of course.
I told you earlier, this administration has a knack for making the extraordinary sound ordinary. And it just happened right there. There you have it. Donald Trump's former personal lawyer says he will consider the president's views on individual prosecutions, and he will not pledge that the Justice Department will act independently of the White House. Blanche is making presidential involvement in individual criminal matters sound routine. It is not. Yes, the Justice Department is, in fact, part of the executive branch. But the executive authority is not the same thing as directing individual prosecutions for personal or political reasons. That distinction is actually one of the main lessons of Watergate. After Watergate, the country put laws, protections, and just as importantly, norms around presidential power and Justice Department independence. And many of those norms were never actually codified into law, which means they survive only if the people in power respect them. This isn't just about one Todd Blanche interview, though. It is clear Donald Trump wants to use the Justice Department as his personal law firm. After relentless scandals, the American public is now overwhelmed, and eventually what once seemed unbelievably abnormal starts to look ordinary. 53 years after Watergate, we are now watching those norms and the independence of the Justice Department being tested once again. Joining us now is Barbara McQuade, former U.S. attorney and law professor at the University of Michigan Law School. She is also an MS Now legal analyst and the author of The Fix, Saving America from the Corruption of a Mob-Style Government. Barb, I do not want people to gloss over what, in my opinion, Todd Blanche is very skilled in doing. And he really does say the most insane, crazy, like, should be stop you in your tracks things. But because he says it so benign, because he sounds like just another regular lawyer, he doesn't say it with much emotion, I think it can go over people's heads. So what does it mean for Blanche to say that there is no independence of the White House and when it comes to these prosecutions, or frankly, what the Justice Department does every day?
You are spot on, Simone, and listening carefully to what Todd Blanche is saying, because it is an absolute distortion of the norms of DOJ in the post-Watergate era. Todd Blanche, no doubt, was a skillful white-collar defense attorney when he was defending clients, including Donald Trump, by doing exactly what you said, embracing these outrageous claims and treating them as if they're absolutely normal. It's as if he is saying, well, of course my client had the smoking gun in his hand. That just proves how innocent he is. Why would a murderer hold a smoking gun? I mean, that's what he seems to be saying here. And you draw the absolute correct distinction. Presidents since Watergate have certainly been entitled to direct categories of crime. I would like you to prioritize violent crime. I would like you to prioritize even immigration enforcement. That is a president's prerogative. But what we have prohibited the White House from doing since Watergate is to direct the Justice Department to prosecute specific cases. In fact, until now, there's been a ban on even communicating about specific cases. And the memos that memorialize that understanding say not only does the Justice Department need to be free from partisan politics, it needs to be free from even the appearance of partisan politics, because that can so undermine public trust in the rule of law.
Okay, Barb, one more question about this, because you just took me back to when I worked in the White House, and I was a senior advisor to the vice president, a deputy assistant to the president. And before we even got into the White House, we had a very clear briefing about who in the executive office of the president was allowed to even contact people over at the Justice Department. And I'm not even kidding. There were maybe about 6 people on that list. But it strikes me that rule, if you will, was just a norm. It wasn't a law. And so the ban that you just spoke about, it wasn't a law. It's not a law. And so is one of the lessons, not just from post-Watergate, but one of the lessons coming out of this moment, should it be that there needs to be more actual laws on the books and not just norms that we expect everyone to adhere to?
Yes, I think so. I think there's some concern that it could violate the constitutional separation of powers to prohibit the president from talking directly to his attorney general. But I think what we could have is, instead of a congressional statute, we could at least have federal regulations. They would go through the notice and comment period. They'd be codified in the Code of Federal Regulations. And then if some president were to try to violate it, there would be a regulation on the books. And so there would be a violation. It would be more than a norm. It would have some teeth. And I think that is an excellent idea for the next administration to try to enshrine some of these norms into the law.
I think I have an idea about who should lead that task force. She's on this screen and it's not me. Okay, before I let you go, the Supreme Court today, they did some things. They rejected Trump's latest attempt to overturn the $5 million E. Jean Carroll verdict. The court, they ended up leaving the verdict standing. Trump continues to fight a separate $83 million defamation judgment. Do you think this is one of the examples of the limits of power of the presidency and why an independent judiciary matters?
Absolutely. These verdicts come against Donald Trump in his personal capacity, not as the president, but as an individual who courts have found, or juries have found, defamed an individual. And so, I think this court is sometimes seen as in the bag for Donald Trump. I don't see him so much as in the bag for Donald Trump as very much aligned with his worldview about presidential power. And so when it comes to the exercise of presidential power, they very much embrace this unitary executive theory. But when it comes to individual issues, I think that they are holding the line on the law, and he's going to have to pay up.
He's going to have to pay up. Barbara McQuade, thank you so much for your time. Have a good night.